Eileen Carol Wuornos was an American serial killer. In 1989 to 1990, while engaging in street work along highways in Florida, she shot dead and robbed 7 of her male clients. She claimed that her clients had either arred or attempted to arr her, and that the homicides of the men were committed in self-defense. She was sentenced to death for 6 of the murders. She was executed on the 9th of October 2002 by lethal injection after spending more than 10 years on Florida's death row. In the feature film Monster 2003, her story is described from her first murder until her execution. For her portrayal of Wuornos, Charlize Theron won the Academy Award for Best Actress. Born Eileen Carol Pittman on the 29th of February 1956 in Rochester, Michigan, her mother Diane Wuornos, born 1939, was 14 when she married Eileen's father, 18-year-old Leo Pittman, 1936 until 1969, on the 3rd of June 1954. On the 14th of March 1955, Eileen's older brother, Keith, was born. After less than 2 years of marriage and 2 months before Eileen was born, Diane filed for divorce. She gave birth to Eileen at the age of 16. Wuornos never met her father. In 1969, Leo Pittman was sentenced to life imprisonment. He was diagnosed with schizophrenia. He later committed suicide by hanging in prison on the 30th of January 1969. In January 1960, when Wuornos was almost 4 years old, Diane abandoned her children, leaving them with their maternal grandparents, Laurie and Britta Wuornos, both alcoholics who legally adopted Keith and Eileen on the 18th of March 1960. Laurie and Britta were Americans of Finnish descent. By the age of 11, Wuornos began engaging in sexual activities in schools in exchange for cigarettes, drugs, and food. She also exchanged sexual activities with her brother. In 1970, at the age of 14, she became pregnant after being arred by a family friend. She gave birth to a boy at home for unwed mothers on the 23rd of March 1971, and her child was placed for adoption. A few months after her son was born, she dropped out of school about the same time that her grandmother died of liver failure. When she was 15, her grandfather threw her out of the house and she began living in the woods near her old home and supported herself through S-work. On the 27th of May 1974, at 18, she was arrested in Jefferson County, Colorado for a DUI, disorderly conduct, and firing a .22 caliber pistol from a moving vehicle. She was later charged with failure to appear. In 1976, she hitchhiked to Florida, where she met 69-year-old yacht club president Louis Gratz Fell. They married quickly, and the announcement of their nuptials was printed in the local newspaper society pages. Wuornos continually involved herself in confrontations at the local bar and went to jail briefly for assault. She also hit Fell with his own cane, leading him to gain a restraining order against her within weeks of the marriage. She was sent to Michigan, where on the 14th of July 1976 she was arrested at Bernie's Club in Mansalona, Antrim County, and was charged with assault and disturbing the peace for throwing a cue ball at a bartender's head. On the 17th of July, her brother Keith died of esophageal cancer, and Wuornos received $10,000 from his life insurance. Wuornos and Fell annulled their marriage on the 21st of July after only 9 weeks. In August 1976, Wuornos was given an $105 fine for drunk driving. She used the money she inherited from her brother to pay the fine and spent the rest within 2 months buying luxuries, including a new car, which she wrecked shortly afterwards. In 1976, at the age of 22, she attempted suicide by shooting herself in the stomach. Between ages 14 and 22, she attempted suicide 6 times. On the 20th of May 1981, she was arrested in Edgewater, Florida, for the armed robbery of a convenience store when she stole $35 and 2 packets of cigarettes. She was sentenced to prison on the 4th of May 1982 and released on the 30th of June 1983. On the 1st of May 1984, she was arrested again for attempting to pass forged checks in a bank in Key West. On the 30th of November 1985, she was named in a suspect in the theft of a revolver and ammunition in Pasco County. On the 4th of January 1986, she was arrested in Miami and charged with car theft, resisting arrest, and obstruction of justice for providing identification bearing her aunt's name. Miami police officers found a .38 caliber revolver and a box of ammunition in the stolen car. On the 2nd of June 1986, Volusia County deputy sheriffs detained her for questioning after a male companion accused her of pulling a gun in his car and demanding $200. She was found to be carrying spare ammunition, and the police discovered a .22 pistol under the passenger seat she had occupied. In 1986, then aged 30, she met 24-year-old Tyra Moore, a motel maid at the Daytona Beach gay bar called Zodiac. They moved in together, and Mona supported them with her earnings as a S-worker. On the 4th of July 1987, Daytona Beach police detained Wuornos and Moore at the bar for questioning regarding an incident in which they were accused of assault and battery with a beer bottle. On the 12th of March 1988, Wuornos accused a Daytona Beach bus driver of assault. She claimed that he pushed her off the bus following a confrontation. Moore was listed as a witness to the incident. Later at her trial, Wuornos stated, before her execution, Wuornos claimed to still be in love with Moore. Wuornos murdered 7 men within 12 months. All of the men were motorists between the ages of 40 and 65. Richard Charles Mallory, 51, an electronics store owner in Clearwater, was murdered on the 30th of November 1989. Wuornos claimed that Mallory beat, and sodomized her after he drove her to an abandoned area for Eshel services. Mallory was Wuornos' first victim, and she claimed to have killed him in self-defense. Later, it became known that Mallory had previously been convicted of attempted R in Maryland. Eileen made no mention of this until she stood trial, and Moore never claimed she mentioned it to her. 2 days after the murder, a Volusia County deputy sheriff found Mallory's abandoned vehicle. On the 13th of December, his body was found several miles away in a wooded area. He had been shot several times, and 2 bullets in the left lung were found to have been his cause of death. David Andrew Spears, 47, a construction worker in Winter Garden. He was declared missing on the 19th of May 1990. On the 1st of June 1990, his naked body was found along US 19 in Citrus County. He had been shot 6 times with a .22 pistol. Charles Edmund Cax-Cadden, 40, part-time rodeo worker, was murdered on the 31st of May 1990. On the 6th of June 1990, his naked body was found in Pasco County. He had been shot 9 times with a .22 caliber weapon. His body had been wrapped in an electric blanket and was badly decomposing when found. Witnesses saw Wuornos in possession of his car, and Wuornos had also pawned a gun identified as belonging to him. Peter Abraham Seames, 65, retired merchant seaman. In June 1990, Seaman left Jupiter, Florida for Arkansas. On the 4th of June 1990, his car was found in Orange Springs, Florida. Moore and Wuornos was seen abandoning the car after Wuornos' handprint was found on the interior door handle. His body was never found. Troy Eugene Burgess, 50, sausage salesman from Ocala, Florida. On the 31st of July 1990, he was reported missing. On the 4th of August 1990, his body was found in a wooded area along State Road 19 in Marion County. He had been shot twice. Charles Richard Humphreys, 56, retired United States Air Force Major, former state child abuse investigator and former chief of police, was murdered on the 11th of September 1990. On the 12th of September 1990, his body was found in Marion County. He was fully clothed and had been shot 7 times in the head and torso. His car was found in Suwannee County. Walter Gino Antonio, 61, trucker, security guard and reserve police officer. On the 19th of November 1990, his nearly naked body was found near a remote logging road in Dixie County. He'd been shot 4 times. 5 days later, his car was found in Brevard County. On the 4th of July 1990, Wuornos and Tyra Moore abandoned victim Peter Seames' car after they were involved in an accident. Rhonda Bailey, who witnessed the accident, provided police with a description of 2 women, which later led to a media campaign to locate them. Police also found some of the victims' belongings in pawn shops. Wuornos' fingerprint that was found on a receipt at one of the pawn shops matched the print that was left on Seames' car. Wuornos had a criminal record in Florida, and samples of her prints were in a database. On the 9th of January 1991, Wuornos was arrested at the Last Resort Biker Bar in Volusia County on the pretext of outstanding warrant in her name of Laurie Grody. Police located Moore the next day in Pittston, Pennsylvania. She agreed to elicit a confession from Wuornos in exchange for immunity from prosecution. Moore returned with the police to Florida, where she was put up in a motel. Under police guidance, she made numerous telephone calls to Wuornos, pleading for her help in clearing her name. 3 days later, on the 16th of January 1991, Wuornos confessed to the murders. She claimed that the men had tried to R her and killed them in self-defense. In November 1991, she was legally adopted by 44-year-old Eileen Prale, with whom Wuornos had no previous contact or relation after Prale simply saw Wuornos' photo in a newspaper. On the 14th of January 1992, Wuornos was sent to trial for the murder of Richard Charles Mallory. Although previous convictions were normally inadmissible in criminal trials, under Florida's Williams rule, the prosecution was allowed to introduce evidence related to the other crimes to show a pattern of illegal activity. On the 27th of January 1992, she was convicted of Mallory's murder with the help from Moore's testimony. After sentencing, psychiatrists for the defense testified that she was mentally unstable and diagnosed her with BPD and antisocial personality disorder. 4 days later, she was sentenced to death. Her defense made efforts during the trial to introduce evidence that Mallory was previously convicted for attempted R in Maryland and served a sentence in a maximum security correctional facility providing remediation for actual offenders. Records obtained from the correctional institution showed that from 1958 to 1962, Mallory was committed for treatment and observation resulting from a criminal charge of assault with intent to R. These records also reflect 8 years of overall treatment in this facility. In 1961, however, the judge refused to allow the records to be admitted in the court as evidence and denied Wuornos' request for a retrial. On the 31st of March 1992, Wuornos pleaded no contest in the murders of Charles Richard Humphreys, Troy Richard Burness, and David Andrew Spears, saying that she wanted to. In a statement to the court, she said, in part, on the 15th of May 1992, she was given 3 more death sentences. In June 1992, she pleaded guilty to the murder of Charles Edmund Carskadden. In November 1992, she received her 5th death sentence. In February 1993, she pleaded guilty to the murder of Walter Gino Antonio and was sentenced to death again. No charges were brought against her for the murder of Peter Abraham Seams, as his body was never found. In all, Wuornos received 6 death sentences. She told several inconsistent stories about the killings. She claimed initially that all 7 men had either arred or attempted to arr her while she was working as a S-worker, but later recanted the claim for self-defense, citing robbery was a desire to leave no witness as the reason for the murder. During an interview with documentarian Nick Broomfield, when Wuornos thought the cameras were off, she told him that it was, in fact, self-defense, but she could not stand being on death row, where she had been for 10 years at that point, and wanted to die. She was incarcerated at the Florida Department of Corrections Broward Correctional Institution death row for women, then transferred to Florida State Prison for execution. Her appeal to the U.S. Supreme Court was denied in 1996. In a 2001 petition to the Florida Supreme Court, she stated her intention to dismiss her legal counsel and terminate all pending appeals. She wrote, while her attorneys argued that she was not mentally competent to make such a request, Wuornos insisted that she knew what she was doing, and the court-appointed panel of psychiatrists agreed. In 2002, Wuornos began accusing prison patrons of tainting her food with dirt, saliva, and urine. She said that she had overheard conversations among prison personnel and she also complained of strip searches, tight handcuffing, door kicking, frequent window checks, and low-pressure mildew on a mattress, and workers threatened to boycott showers and food trays when certain officers were on duty. Her attorney stated that he added, in the weeks before her execution, Wuornos gave a series of interviews to documentarian Nick Broomfield and talked about in a final interview, she once again charged that her mind was at BCI and that her head was crushed by food poisonings and other abuses worsened, she said, each time she complained to make her appear insane or drive her insane. She turned to the interviewer. Her final on-camera words were, Dawn Botkins, a childhood friend of Wuornos, later told Bloomfield that her verbal abuse was directed at society and the media in general, not him specifically. Her execution by lethal injection took place on the 9th of October 2002. She declined her last meal, which could have been anything under $20, and opted for a cup of coffee instead. Her last words were, she died at 9:47 a.m. EDT. She was the second woman in Florida and the 10th in the US to be executed since the 1976 United States Supreme Court decision restoring capital punishment. After her death, her body was cremated. Her ashes were scattered beneath a tree in Michigan by her childhood friend Dawn Botkins. At Wuornos' request, Natalie Merchant's song Carnival from her album Tiger Lily 1995 was played at her funeral. Wuornos spent many hours listening to this album while on death row. While Merchant found out about this, she gave permission to use it as a song in the closing edits of Nick Broomfield's documentary Eileen, Life and Death of a Serial Killer 2003. When director Nick Bloomfield sent a working edit of the film, Broomfield later speculated on Wuornos' state of mind and motives. According to some specialists, Wuornos' crimes have been related to her psychopathic personality and a psychotraumatic past. Assessed during the psychopathy checklist, she scored 32 out of 40 with a cut-off score of 30 before determining psychopathy. She was known to meet the relevant criteria for determining BPD and antisocial personality disorder. According to Bryce Arrigo, her childhood sexual abuse and career in S-work irrevocably damaged her, and it could be seen that traumatic experiences throughout most of her young life would play a part in her psychological state, including her biological mother's departure as well as her grandmother ignoring the abuse she endured from her grandfather, thus leading to a lack of development of a mother-daughter bond for Wuornos as a young girl. The damage was then made worse because both Wuornos and her brother believed that the grandparents were their biological parents, but at the age of 11 they learned that this was not the case, which further damaged the relationship between Wuornos and her adoptive parents. Wuornos was also known to have early behavioural problems such as having an explosive temper, which limited her ability to make friends, as well as making it increasingly difficult for her to maintain relationships. Her traumatic upbringing, including her physical and sexual abuse, have been partially linked to the development of her BPD. Such severe trauma can be said to also disrupt the structuralization of the mind at various developmental points and result in FBI profiler Robert Ressler briefly mentions Wuornos in his autobiographical history of his 20 years with the FBI, writing in 1992 that he said that he often does not discuss female serial killers because they tend to kill in sprees instead of in a sequential fashion. He noted Wuornos as the sole exception. Ressler, who allegedly coined the term serial killer to describe murderers seeking personal gratification, does not apply to women killing in postpartum psychosis or to any murderer acting solely for financial gain, such as women who have killed a series of boarders or spouses. Sharon Kin, also known as Jeanette Pergolese and La Pistorella in Mexico, and Deirdre Grace D. Glabus, later Deirdre L. in Canada, was an American murderer, suspected serial killer and prison escapee who was convicted in Mexico for one murder and is suspected of two others in the US, one of which she was acquitted at trial. She was the subject of the longest outstanding arrest warrant for murder in the history of Kansas City, Missouri, and one of the longest outstanding felony warrants in US history. While her case is officially closed, authorities still seek information about her movements after 1969. Sharon Kin was born Sharon Elizabeth Hall on the 30th November 1939 in Independence, Missouri, to Eugene and Doris Hall. The family were devout members of the Reorganized Church of Jesus Christ of Latter-day Saints, now known as the Community of Christ, a denomination of the Latter-day Saint movement. When she was in junior high school, her parents moved the family to Washington State, but by the time she was 15, they returned to Missouri. In the summer of 1956, then aged 16, she met James Kin, a 22-year-old student, at Brigham Young University while attending a church function. The couple dated regularly until James returned to BYU that fall. Sharon, reportedly deeply interested in finding a partner with prospects who could take her away from Independence, wrote a letter to James claiming that she was pregnant by him. James took leave from the BYU and returned to Independence, where he married Sharon on the 18th of October 1956. Their marriage license falsely identified Sharon as being 18 and a widow. Although she later refused to address why that was there, Sharon told people at the time that she had been married when she lived in Washington to a man who later died in a car accident. The new couple held a second, more formal wedding the following year at the Salt Lake Temple in Salt Lake City, Utah, after Sharon had completed the process of joining the Church of Jesus Christ of Latter-day Saints. After the wedding, they returned to Provo, Utah. James resumed his studies at BYU, but put them on hold again at the end of 1956's fall semester. The couple returned to Independence, where they both took jobs. Sharon babysat and tended shops, whilst James worked as an electrical engineer at Bendix Aviation. Although Sharon claimed to have miscarried the child that had brought about their marriage, she soon became pregnant again. In the fall of 1957, she gave birth to a girl the couple named Dana. Sharon was reportedly a lavish spender who expected finer things out of life, but on James's salary they lived first in a rented home next to their parents' residence, then in a ranch-style house they had built at 17009 East 26th Terrace, Independence. James worked the night shift at Bendix, and Sharon filled her days with shopping and later other men. By the time the couple had had their second child, a boy named Troy, Sharon was carrying on a regular extramarital affair with a friend from high school named John Baldiz. In early 1960, James was contemplating divorce, partially because of Sharon's spending habits, and particularly because he strongly suspected her infidelity. He spoke to his parents about the possibility of divorce the day before his death, telling them that Sharon had agreed to give him one if he allowed her to keep the house, gave her custody of the couple's daughter, and paid $1,000 in alimony. James' parents, devoted Latter-day Saints, urged him to stay in the marriage. Sharon also was thinking about ways out of the marriage, according to Baldiz. She once offered him $1,000 to kill her husband, or find someone that would, although he later claimed that she might have been joking. According to Sharon, on the 19th of March 1960, at around 5:30 p.m, she heard a gunshot from the direction of the bedroom in which James was sleeping. Entering the room, she found her 2.5-year-old daughter, Dana, in the bed next to her father. Dana was holding one of James's guns, a high-standard .22 pistol, and James was bleeding from an apparent gunshot wound at the back of his head. Sharon then called the police, but James was dead by the time the ambulance carrying him arrived at the hospital. Police were unable to recover any fingerprints from the well-oiled grip of the pistol, and the paraffin test for the gunshot residue was not performed on either Dana or Sharon. Multiple people, including family and neighbours, told police that James had often allowed Dana to play with his guns, and in a test by investigating officers, Dana proved able to pull the trigger on a gun matching the one that had killed her father. With no evidence to the contrary, investigators ruled the case as an accidental homicide. The pistol that killed James was taken into police custody and never returned to Sharon. Despite her efforts to reclaim it, she later had a male friend secretly buy her a .22 caliber automatic pistol. When a friend told Sharon that he had registered the gun in her name, she requested that he re-register it under a name other than hers. With the investigation into his death closed, James was buried and Sharon collected on his insurance policies, valued at about $29,000, $230,000 in present day. Patricia Jones, born Patricia Clements, was one of 6 children born to Mr. and Mrs. Elmer Clements of St. Joseph, Missouri. After graduating from Benton High School, she married Walter T. Jones Jr., her high school sweetheart. Walter enlisted in the United States Marine Corps shortly after their marriage, and the couple relocated to the West Coast during Walter's service. After he received his discharge, the couple returned to Missouri and settled in Independence with their 2 children. By 1960, almost 5 years into their marriage, Jones was working as a file clerk for the Internal Revenue Service while her husband was a car salesman. Despite his marriage and children, Walter reportedly had a wandering eye. On the 18th of April, Walter met Sharon when she bought a Ford Thunderbird from his dealership using the insurance payout from her husband's death. The two began an affair shortly after. Sharon viewed Walter as a prospect for a second husband, but he was uninterested in leaving Patricia despite difficulties in their marriage. When Walter declined to join her on a trip to Washington State in May, Sharon reluctantly went with her brother Eugene instead. Although they reunited on the 25th of May, the relationship became fraught when Sharon told Walter that she was pregnant with his child. Instead of responding with what Sharon expected to be an agreement to divorce Patricia, Walter simply ended the affair. According to a later testimony, on the afternoon of the 26th of May, Sharon contacted Patricia at her office and told her that Walter was having an affair with Sharon's sister. Sharon then met Patricia that evening to discuss the matter further before dropping her off near the Jones residence. After Patricia failed to return home that evening, Walter filed a missing persons report with police and the next day began calling people he thought who might have seen his wife. He got a lead when he spoke to one of Patricia's friends who carpooled to work with her. They told him that Patricia had reported receiving a phone call that day from an unnamed woman who wanted to meet with her. She had asked the carpool driver to drop her off at a street corner in Independence, which he had done. The occupants of the carpool had seen a woman waiting for Patricia in another car, but they didn't recognize her. They nevertheless provided a description of the unknown woman to Walter. Suspicious of the identity of the woman based on the couple's general description, Walter called Sharon and asked if she'd seen or spoken to his wife. Sharon allowed that she'd seen Patricia that day. She had met her to tell her about Walter's affair. According to Sharon, she last saw Patricia when she dropped her off near the Jones residence, speaking to an unknown man in a green 1957 Ford. Based on her admission over the phone, Walter met with Sharon late Friday evening and insisted she give him more details about where his wife was. He later admitted to going as far as holding a key to her throat threateningly. Sharon's response was, after leaving Walter, to call Baldies and ask him to help her search for Patricia. Shortly before midnight, within hours of her conversation with Walter, Sharon and Baldies found the body of a woman in a secluded area approximately 1 mile outside of Independence. According to Baldies, he had been the one to suggest searching that area in which they encountered the body. It was a spot to which they had often gone on dates before. The body, dressed in a black sweater and yellow skirt, was soon identified as Patricia's. She had been shot 4 times by a .22 caliber pistol. Although the fatal wound was a shot to the head, entering near her mouth in an upward trajectory, she also had one through-and-through bullet wound to her abdomen and 2 penetrating gunshot wounds to her shoulders on a downward trajectory through her body. Powder burns on the hemline of her skirt, which had been raised to her waist, indicated that the gun had been fired from close range at least once. Initial reports and investigation placed Patricia's time of death at approximately 9 p.m. on the 27th of May. She was buried on the 31st of May. Investigators immediately began to question Sharon, Walter and Baldies. All 3 were questioned on the 28th of May. Walter and Baldies both gave written statements admitting that they had dated Sharon, and both agreed to lie detector tests. Sharon gave an oral statement to police but declined to sign a written one or take a lie detector test. She was questioned again on the morning of the 30th of May and Baldies on the 31st of May. The scheduled lie detector tests for the 2 men were performed on the 1st of June, and both men were deemed to have been truthful in their statements. Sharon's brother Eugene was also interviewed on the 31st of May, but declined to answer questions. While police questioned potential suspects and witnesses, other investigators focused on processing the crime scene. Repeated attempts were made to find the murder weapon and the bullet that had passed through Patricia's body, including the sifting of dirt at the crime scene and the deployment of a troop of Boy Scouts. A .22 caliber rifle slug was eventually found buried in the ground where Patricia's body had been found, providing evidence that at least some of the wounds had been sustained at the place where her body was found. Although investigators went as far as to drag the bottom of nearby bodies of water, the gun that had shot Patricia, assumed to be a .22 caliber pistol, couldn't be found. Buildings near the crime scene were also searched for blood and gunshot evidence, in accordance with the police's theory that Patricia had been attacked elsewhere and then transported outdoors. Found in her hair was initially believed to be a trace evidence of some other crime scene area, an idea that fueled the search of nearby buildings but was later determined to be fly eggs. Sharon was arrested at her home for Patricia Jones's murder at around 11 p.m. on the 31st of May, the same night as Patricia's funeral. The same day, the Jackson County Sheriff requested that prosecutors consider a second charge of murder, this one for the death of James Kinn. Sharon's lawyers, Alex Peebles and Martha Sperry Hickman, filed a writ of habeas corpus with the court that next morning, and a hearing that afternoon resulted in a release on a $200,000 bond, which she awaited a preliminary hearing originally scheduled for the 16th of June. Police were able to rule out the .22 caliber pistol that had killed James as the murder weapon in Patricia's death. That gun was still in possession of the sheriff's office. However, a man who worked with Sharon admitted having secretly purchased a new .22 caliber pistol at her request in the beginning of May. Police were unable to locate the gun in question when they searched her house, though they did find an empty box which they believed to have once held a gun. Sharon at first claimed to investigators that she'd lost the gun on a trip to Washington, then stated simply that the gun had just disappeared. Walter was taken into custody on the 2nd of June as a material witness to the case and was freed the same day on a $2,000 bond. The initial autopsy performed on Patricia was criticised by police and prosecutors, who felt that the recovery of bullets and testing of stomach contents should have been done. Dr. Hugh Owens, who had performed the autopsy, argued that he had recovered one of the presumed 3 bullets present in the body, and that because the body had been prepared by an undertaker prior to autopsy, any chemical tests on the stomach contents would have been useless. Owens did add when asked that he had not seen any food apparent in the stomach at autopsy. Patricia's body was exhumed on the 17th of June in order to collect the bullets that had been left behind at the original autopsy. as well as to gather what samples of tissue and stomach contents were possible. Sharon's arraignment on the 11th of July resulted in denial of bail, but the Missouri Court of Appeals struck down the ruling days later based on the prosecution's reliance on circumstantial evidence. She was freed on a $24,000 worth $188,976 in 2013 bond on the 18th of July. After a delay in her trial date due to her advanced pregnancy, Sharon gave birth to a daughter named Marla Christine on the 16th of January 1961. Although charged with both murders, Sharon was tried separately for the two crimes. The trial for the murder of Patricia Jones began in mid-June 1961, with jury selection beginning on or about the 13th of June, and the trial commencing days later with an all-male jury. Opening arguments by both prosecution and defence set up cases based on purported times of death, basing their assertion on pathologists' given testimony that Patricia had died about 6 hours after she ate lunch on the 26th of May. The prosecution claimed that Jones had died more than 24 hours before Sharon and Baldis found her body. Defence attorneys argued that the death more likely occurred 6 to 8 hours prior. Prosecutor J. Arnott Hill cited testimony by Walter Jones and Chief of Detectives Lieutenant Harry Nesbitt as evidence of Short's motive for the crime. Nesbitt recalled statements by Sharon that she was afraid Walter was drifting away from her despite the financial support she offered him, and Walter testified that Sharon had told him that she was pregnant by him and he had thereafter attempted to end the relationship. The prosecution was unable to firmly establish that Sharon owned or had once had the weapon that killed Patricia, though both Sharon's known pistol and the one that fired the bullets that killed Patricia were .22 caliber weapons. Roy Thrush, the man who sold the pistol to Sharon's male friend, had led police to a tree that contained where he claimed to be the bullets that he had fired from that pistol. However, when the bullets were extracted from the tree trunk, tests showed that the extracted bullets were not identifiable as having come from the weapon that killed Patricia. The prosecution rested its case on the 21st of June after calling 27 witnesses. Sharon's defence, which took less than 2 days and involved 14 witnesses other than Sharon who didn't testify, focused on breaking down the state's claims of motive and means, arguing that she had no reason to kill Patricia and that the pistol she was alleged to have owned had not been proven to be the murder weapon. After slightly over 1.5 hours of deliberation, the jury, citing just too many loopholes left in the prosecution's case, acquitted Sharon Kin. Immediately after the delivery of the verdict, juror Ogden Stevens asked Sharon for his autograph, which she was photographed given to him. Sharon was returned to jail the same day to await trial for the murder of her husband. Despite her acquittal of the murder of Patricia Jones, Sharon remained charged for the murder of her husband James Kin. When jury selection began on the 8th of January 1962, Hill announced that he didn't intend to pursue the death penalty in this case. The prosecution's case rested largely on their contention that Sharon had been so interested in seeing her husband removed that she'd been willing to pay for his murder, supported by the grand jury testimony of Baldis. Baldis, though nominally a witness for that prosecution, weakened his testimony on the stand during the trial by claiming that Sharon's offer to pay him $1,000 in return for James's murder could have been a joke, and Hill was forced to attack his own witness's credibility. Further prosecution testimony alleged that the Kins' marriage had been on the verge of dissolution at the time of James's death, and that Sharon's adultery had been a cause of this, and that Sharon had known that she would collect her husband's $29,000 life insurance policies only if she was still his wife. The defence, led by attorneys Hickman and James Patrick Quinn, focused on the circumstantial quality of the prosecution's evidence, noting that prior police investigation had determined James's death to be obviously accidental, and that the jury was obligated to assume innocence on the defendant's part, no matter how unpleasant they found her moral character to be. The defence too attacked the reliability of Baldis' testimony, calling him a poor mixed-up kid who would sign anything. Kin's attorneys also presented testimony from witnesses supporting the viability of the theory that Dana had shot her father, including statements that gun had been regularly left within her reach in the family home, that she was able to pull the triggers on toy guns with stiffer trigger pulls than the weapon that caused James's death, and that she'd often been observed pretending to fire guns in play. The trial ended in conviction on the 11th of January after 5.5 hours of deliberation. In April of the same year, Sharon was formally sentenced to life in prison. She began to serve her sentence in the Missouri Reformatory for Women, Later interviews with jurors from the trial revealed that 3 or 4 ballots had been taken before the guilty verdict was reached, beginning with the jury solidly divided and moving progressively towards unanimity for conviction. One juror told Kansas City Star that Sharon's morals had not been considered an issue at the jury, and that she thought no juror had been aware of her previously being tried for the murder of Patricia Jones. Despite the verdict, James's family continued to believe the best in their daughter-in-law, telling reporters on the day of the verdict, and Sharon herself told reporters that she felt the verdict was a mistake and that she regretted her previous enthusiasm for having women on the jury. The following week, Sharon's lawyers requested that she be released on bond, supported by a community petition signed by 132 supporters of her innocence. The motion was denied on the basis of first-degree murder not being a ballotable offence. Presiding Judge Tom J. Stubbs also counselled Sharon's lawyers that he felt their involvement in such a petition at a time when a motion for bond was being considered highly improper. A subsequent defence motion requested that the conviction be vacated because the jury had delivered its verdict based on summarising speculation rather than substantial evidence, listing a series of procedural errors that Sharon's counsel alleged had taken place before and during the trial. These included juror taking incomplete notes, disputes over Balder's testimony, and an incorrect number of potential jurors being provided for the selection. The motion was denied by Judge Stubbs in April 1962, but appealed to the Missouri Supreme Court, which in March 1963 reversed the conviction and ordered a new trial on the basis of Sharon's defence having been denied adequate peremptory challenges during the jury selection in her trial. Sharon was denied an opportunity for bail in 1963, but that ruling was overturned in July when she was released on a $25,000 bond posted by her brother Eugene. The state's request that the Missouri Supreme Court reconsider its position on Sharon's conviction was granted, but in October 1963, that hearing resulted in further grounds being found for a new trial, this time on the basis of the prosecutor having been allowed to cross-examine a prosecution witness. A second request for a rehearing on the validity of the conviction was denied by the Missouri Supreme Court. Sharon and her children moved in with her mother and awaited the start of the new trial. Sharon's second trial for the death of James Kane began on the 23rd of March 1964. A jury selection got underway that day. The public was initially barred from the proceedings, but the restriction was soon loosened and journalists were allowed into the courtroom. An unusually long jury selection process made the first day of the trial last 14 hours, beginning at 9 a.m. and not ending until nearly midnight. Presiding Judge Paul Carver noted that due to the notoriety of the case, he'd been forced to choose between sequestering the entire jury pool overnight or forcing the court into a long day. The eventual jury, all men, were immediately sequestered, but days later a mistrial was declared after it emerged that the law partner of the prosecutor, Lawrence Shepard, had once been retained by one of the jurors. Sharon's third trial in the death of her husband, originally scheduled to begin in early June 1964, began instead on the 29th of June. Assistant Prosecutor Donald L. Mason declared at a jury selection that he intended to death qualify the jury, a process in which a prosecutor preemptively challenges any juror who automatically opposes the death penalty, and jury selection once again took more than 12 hours in one day. Balder's testimony in this trial remained contradictory as to whether he believed Sharon's $1,000 offer to have James killed had been intended seriously, but he added that at the time of his death, Sharon had asked that Baldus not tell authorities about her offer. A new witness, a female acquaintance of Sharon's, testified that she had once joked that the woman should. But defense cross-examination highlighted inconsistencies between this testimony and a similar quote that the woman had offered at a previous deposition. For the first time at any of the trials, Sharon took the stand on the last day of this trial to issue a categorical denial of all charges. The all-male jury deadlocked 7-5 in favour of acquittal in this trial, resulting in a second mistrial. A fourth trial was scheduled for October 1964. However, in September, Sharon, still free on her $25,000 bond, travelled to Mexico with her alleged lover, Francis Samuel Pugliese, leaving her children with James's father and travelling as Pergolesi's wife under the name Jeanette Pergolese. The couple later said that they had gone to Mexico to get married. Under the legal terms of her bail, Sharon was permitted to leave the country, but her contract with the company that posted her bond prohibited her from leaving Missouri without written permission from the company's agent. After crossing the border, Sharon and Pergolese registered at a local hotel, Hotel Gin, again as husband and wife. Sharon, saying that she felt unsafe in a foreign country, bought a pistol, which meant that the couple now possessed multiple guns, having bought one or two with them from the US. On the night of the 18th of September, Sharon left the hotel without Pergolese, either to acquire money because the couple had been running low or to get the medicine she required. She encountered Francisco Paredes Ordonez, a Mexican-born American citizen, at a bar and accompanied him back to his room in Hotel Lavada. According to her account, Sharon went with Ordonez to see photographs he offered to show her, but he soon began to make sexual advances toward her, and she was forced to fire her gun at him in an attempt to protect herself. Sharon maintained later that she had no intention of harming or killing Ordonez, and that she intended only to frighten him, but her bullets stuck him in the chest and killed him. Responding to the sound of gunfire, hotel employee Enrique Martinez Rueda entered the room. Sharon fired again and hit Rueda in the shoulder. Wounded, Rueda fled the room, locking Sharon inside, and called police. Police, rejecting Sharon's story, theorized that she had gone out that evening intending robbery and had chosen Ordonez as her victim. When he resisted her orders to give her his money, police believed that Sharon had simply shot him. Police responding to Hotel Lavada arrested Sharon on charges of homicide and assault with a deadly weapon. She maintained that she hadn't intended to harm Ordonez and that she had fired her weapon at Rueda because she feared that he too was coming to attack her. Police searched her purse, finding a gun with 50 cartridges, and then the couple's room at Hotel Gin, where they found 2 more guns and another supply of cartridges. Authorities took Pergolese into custody at the Hotel Gin, initially holding him without charge and later filing charges of entering the country illegally and carrying an unlicensed gun. The gun found in the couple's room later that night was later proven through ballistics to be the same gun that killed Patricia Jones in 1960. But because Sharon had already been acquitted of that crime, she could not be charged again for it based on the new evidence. Pergolese was held at the Palacio de Lecumberri in Mexico City, where she was initially placed in the women's prison before being transferred to Lecumberri for her trial. The couple were arraigned on the 26th of September and held for trial. In October, her Mexican attorney, Higino Lara, filed a recurso de amparo, similar to a writ of habeas corpus, asserting that the Mexican government was violating her constitutional rights by holding her for a shooting committed in self-defense. The request was denied, and both Sharon and Pergolese were tried in the summer of 1965. Pergolese, cleared of all the charges against him, was deported to the US, but Sharon was convicted on the 18th of October for the homicide of Ordonez. Despite rumours that she would receive probation and be deported like Pergolese, she was instead sentenced to a 10-year prison term for the murder. When she was officially notified of the sentence the next day, she asserted that she would appeal her conviction. However, the appeal backfired, and instead of overturning her sentence, it lengthened it. The 3-man Superior Court that heard the case overturned one aspect of her conviction, charges of attempted robbery, but upheld her murder conviction and increased her sentence to 13 years, saying that the original sentence of 10 years had been too lenient. Sharon was returned to the women's prison to serve her sentence. There she was nicknamed La Pistolera, the gunfighter, a nickname subsequently adopted by the Mexican press. On the 7th of December 1969, Sharon was not present for her routine 5 p.m. roll call at the Iztalapan prison where she was serving her sentence. Her absence was not officially noted until she also failed to show up at a second roll call later that evening. The news of the escape was not reported to Mexico City police until 2 p.m. the following morning. A manhunt was then organised, initially focusing on the northern Mexican states due to authorities' belief that she may have been heading for the last known whereabouts of a former inmate whom she'd grown close with while they were in prison together. The search also encompassed countrywide transport hubs and eventually circled back to the Mexico City area. US authorities, including the FBI, were also alerted of Mexican authorities' belief that she may have been attempting to work her way back into her native country, but the FBI noted that it was unlikely to have jurisdiction in the case. Initial police speculation was that Sharon had bribed guards to look the other way while she escaped the prison. An unusual blackout had been reported at the prison on the evening of and at the approximate time of her escape. Investigation showed that the door that should have been locked had been left unsecured. Further questioning of prison guards and administration showed that oversight of the prison was generally lax and that it was staffed by fewer guards than it should have been. News reports of the time reported numerous theories about her escape, including that she had bribed prison guards, that she may have enlisted the help of a supposed boyfriend who was a Mexico City policeman, that her mother had been involved in the escape plan, that a former Mexican Secret Service agent had assisted in the escape, and that Sharon may have disguised herself as a man to escape. A more recent theory incorrectly speculated that the Ordonez family had helped her escape and then killed her. The intensive manhunt for Sharon was short-lived. By the 18th of December, the Mexican Secret Service and the Mexico City District Attorney Office were both reporting that they were no longer involved in the searching for the escaped prisoner, while the Federal District Attorney was reporting that responsibility for the hunt belonged to the City District Attorney's Office. Investigators speculated that Sharon had already fled to Guatemala, lessening the purpose of a Mexican manhunt. They noted that she was fluent in Spanish after her years in a Mexican prison, and that she could therefore get along rather well in nearly any Spanish-speaking area of the world. Despite vowing to keep the case open and their investigation running until Sharon was back in custody, authorities were forced to admit by the end of December 1969 that they had run out of investigative leads to pursue. Sharon's arrest and conviction in Mexico had implications for the status of her Missouri legal entanglements. Because she was being held in Mexico on the 26th of October 1964, the scheduled date for her fourth trial in the murder of her husband, her $25,000 bond was revoked on that date. Although the United Bond Insurance Company, which had posted the bond, argued that paperwork irregularities rendered the insurance of a bill illegal, the court ordered the company to forfeit the bond. Sharon was reportedly concerned about the monetary implications of this forfeiture. "I could always use the money." At Alice, Oklahoma, Times-Democrat quoted her as saying, "I don't intend to spend my life in jail." A $30,000 stupendous bond was issued in August 1965 as the United Bond Insurance Company continued to dispute the payment of her original $25,000 bond. The bond allowed the company to defer payment of the $25,000 bond until a ruling on the matter was handled by the Missouri Supreme Court. But when that court upheld the bond's forfeiture, the $25,000 bond was paid to the state of Missouri in October 1965. The United Bond Insurance Company later filed the suit against Sharon's family to recover the cost of the bail, lawyers' fees, and manhunt for her after her escape. Shortly before her scheduled Missouri trial date, her Missouri counsel filed a motion to change the venue of any eventual fourth trial in the death of her husband, claiming that news coverage of the case had so prejudiced residents of Jackson County against Sharon that it would be impossible for her to get a fair trial there. When she failed to appear for the fourth trial, a warrant was issued for her arrest in 1964. It was still outstanding at the time of her death, making it the oldest outstanding murder warrant known to exist in the Kansas City area. Her status in the Mexican system also remained outstanding, though authorities pointed out at the time of her escape, jailbreak was not a crime under Mexican law, and if she was recaptured there, she would only have to serve the remainder of her outstanding sentence. Kin as Deidre Glaber stay unknown. In December 2023, the Jackson County Sheriff's Office and the Kansas City Police Department both received an anonymous tip that Sharon had been living in the town of Aber, Alberta, Canada, approximately 121 miles southeast of Calgary, under the alias of Deidre Glaber, nicknamed Dee. Under Canadian law, law enforcement agencies were allowed to obtain fingerprints from deceased persons with criminal records. However, because Deidre had no such record, Canadian police were unable to do so. However, the local funeral home which had handled her remains provided a service preserving fingerprints as mementos for loved ones, which were processed through a company coincidentally based in Independence, Missouri, in the very jurisdiction where Sharon's criminal warrants remained in effect. Jackson County investigators subsequently secured a warrant to obtain Deidre's fingerprints, which were conclusively matched to Sharon's by the FBI. U.S. authorities publicly announced these findings on the 17th of January 2025. Sharon married her second husband, James Thomas Glaber, in LA in February 1970, 2 months after her jailbreak from Mexico. The couple relocated to Tabor in 1973, where they operated a motel and later a real estate agency, advertisements of the latter business showing Sharon's picture were printed in local newspapers. How Sharon was able to obtain a travel visa, identification, and citizenship, despite her status as a fugitive, remains unknown. On the 11th of August 1979, at the age of 38, Glabus died from complications related to diabetes and alcoholism. Sharon was left out of his will, an omission she fought in court. She later married her third husband, William Willie L., in March 1982. L died on the 7th of April 2011 at the age of 79. Sharon herself died of coronary artery disease on the 21st of January 2022 at the age of 82, with Alzheimer's disease being listed as a contributing factor on her death certificate. Both the death certificate and headstone falsely record 1940 as her year of birth. Sharon left behind one son from a marriage to Glabus, in addition to her 3 children in the US. Little is known about all of Sharon's movements following her prison escape. In Tabor, she performed volunteer work, including serving as a chairwoman for a daycare centre steering committee, and was known for needlepoint artistry and playing bridge. While the news of Sharon's death officially closed the case, as of 2025, authorities are still seeking details about her life after 1969. In a segment of the Investigation Discovery series, Deadly Women, covering the case author James Hayes speculated that Sharon committed her first murder for monetary gain, hoping to cash in on James' life insurance policy, and that she began to derive pleasure from killing at that point. Former FBI profiler Candice DeLong supported this assertion, stating that Sharon was a sociopath, lacking in remorse and empathy, and therefore had no compunction about killing to get what she wanted. This idea was echoed by some of those involved in prosecuting Sharon. Even those who believed in her guilt, however, said that she had a certain appeal, describing her as rather attractive and admitting that they grew to like her. The Mammoth Book of True Crime describes her as a relative rarity, a pretty criminal. In I'm Just an Ordinary Girl, The Sharon King Story, Hayes asserts that Sharon was inspired to kill her husband by a magazine article she read about Lillian Chastain, a Virginia woman who shot her husband during an argument and blamed the gunshot on the couple's 2-year-old daughter. Charges against Chastain were filed in February 1960, weeks before James's death.